This Week. I'm George Whipple. Our top story, beginning in 2018, pay history will be off limits for Massachusetts job applications and interviews. In a unique attempt to close the gender wage gap, the state has passed a pay equity law that bars employers from asking applicants about their previous salaries. They'll also be prohibited from seeking the information from an applicant's prior employer. While this provision is the first of its kind in the country, the bill also contains more common equal pay protections, broadens the definition of equal work, and prevents employers from banning the discussion of salary among employees. Mickey Neuhauser has more.
The hope is that by taking the salary question off the table, employers will rely only on relevant factors and won't even unconsciously rely upon an irrelevant factor such as the employee's prior salary. Of interest, the law does not prohibit applicants from disclosing their current salaries or salary history, and it doesn't prevent applicants and employers from negotiating over salary. However, the law does not protect employers from paying a salary lower than what would otherwise be permitted under the Act simply because an individual has agreed to accept that salary. In other words, an employee cannot agree to be illegally underpaid.
The Department of Labor and Subway team up to break new ground. The world's largest fast food franchisor has reached a voluntary agreement with the DOL to provide wage-hour compliance training to franchisees. This partnership will focus on helping the franchisees comply with federal wage and hour laws. While the department hopes to enter into more arrangements like this, franchisors are hesitant, noting that the deal could make them joint employers under the NLRB's standard. New York's crackdown on non-compete agreements continues. An investigation by New York Attorney General Eric Schneiderman revealed that Examination Management Services, Inc. required all of its workers to sign non-compete agreements, even those who had no access to trade secrets or sensitive information. Non-compete agreements in the state are usually only permissible for employees with a high level of access. Under the agreement, the company will stop using non-competes for most employees in New York. A Citigroup affiliate pays a hefty amount for misclassifying workers. A subsidiary of Citigroup in Florida recently paid almost $2 million to workers it had misclassified as exempt from overtime pay. An investigation by the Department of Labor's Wage and Hour Division found that the company mistakenly applied the FLSA's exemption to a group of 882 employees. This case serves as a reminder that salaried workers are not necessarily exempt from overtime. Finally, it's time for our tip of the week. Lisa Glass, Chief Human Resources Officer for the Child Center of New York, is here with some advice on how to create an effective onboarding program.
An important way organizations can help combat employee turnover and help employees adjust to the new organization is through an effective onboarding program. An onboarding program allows employees to understand the expectations of their role in terms of performance as well as social expectations. Effective onboarding is key in creating employee expectations and sharing organizational values. The goals must align with the goals of the organization, and the program initiative must be driven by senior management and not solely driven by human resources.
Thanks, Lisa. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.